This is the second of 3 lectures by Professor Philipp Fischinger of the University of Mannheim, and his third visit here to the University of Illinois as part of the program on comparative labor law and policy. Also, his visit is co-sponsored with the European Union Center. His talk today will focus on the law of union organizing, more or less, in Germany. And just as a way of background, those number of American students have been studying the law of union organizing under our statute, and they know that it's very hard. Our law makes it very hard, very difficult for unions to reach people and to organize them. Union density is in decline in much of the developed world, with the exception of Scandinavia. And German unions, which in the past engaged in sectoral bargaining and had a large sort of lock on the market, now discover that they really, or some of them discovered they really should start organizing. Some, and I'd be interested in knowing which IG Metall is and Verdi, the service union, is not, and why is that so? The question that presents itself is German law an obstacle, anything like here it is in the United States, for unions to get a message out and to get new members? I understand from colleagues in Japan that the Japanese unions are also now beginning to worry about that decline and claim that they can boost membership very significantly. Whether they can or not, I don't know, and I don't know enough Japanese law to know if the law is a problem. It is a problem in the United States. Everyone who's looked at this neutrally and dispassionately says there's something wrong with our law in terms of its the inability of unions to get the message to those they want to target. So this is an aspect of German labor law I know nothing about, and I'm really looking forward to what I would like to think is a more hopeful message, but we'll see.
Thank you, Matt.
Yeah.
Thank you very much. Welcome, ladies and gentlemen. I will talk about this question, and I hope to answer this question, not only to answer it, but also give you a positive message, and I think I can give it. But first, as yesterday, I will just give a short introduction into German law as well. In this case, German labor law, just to give you some background information, not only talking about this topic specific, but also about labor law in general. And afterwards, coming to the specific question of union advertising rights. Let's start with the areas of labor law in Germany. This is a little bit different from the United States, I guess, because we also have, of course, this system of collective bargaining agreement. I will talk about that a little bit later. That's not so much different to the United States. The big difference, I think, is the right of codetermination, which we have in Germany. And actually, there are 2 types of codetermination in Germany. There's first the codetermination on the establishment level, and there's a codetermination on the corporate level, I would call it. The establishment level, for example, is something like a Walmart in Champaign, just one little shop of Walmart, whereas corporate level means Walmart United States or something like that, the whole company, the United States. If you look on the establishment codetermination, it works through and by the Works Council. The Works Council is essentially nothing else than an elected employment representative body. If in the establishment, Walmart, Champaign, for example, if there are more than 5 employees employed, they can choose if they want to have a Works Council election or not. It's absolutely their own decision. They are free to do so. The employer must not interfere with the election. He is not allowed to give any incentives or disadvantages to the employees if they decide to elect for a Works Council or not. And the Works Council members and the nominees for it, they enjoy some special protections, like, for example, a protection against dismissal or protections against being transferred to another establishment. The principle of Works Council is that the Works Council represents the whole, or let's say the whole body of employees, all employees. The Works Council in Germany is rather a parliament. It's not member-based, it's establishment-based, meaning the Works Council represents all employees in this establishment, Walmart, Champaign, even employees that not choose to vote for Works Council in the first place or wanted to other members to be elected to this Works Council. So it's not like the union, which is based on the membership, the voluntary membership. What is the relationship between the Works Council and the employer? The relationship, and this is very crucial, is based on the principle of mutual trust. It's a principle the German employment, the Act, the Works Council Act requires employer as well as Works Council to work together in mutual trust. That essentially means there's a ban on strikes and labor dispute means they are not allowed to engage in industrial action against each other. If they consent, everything is fine. If not, there are other means of settling disputes, and essentially this means is simply a conciliation board. A conciliation board is a board which is built up by people from the employee side and employer side in an impartial chairman, and this conciliation board is the body the employer or the Works Council has to go to if they don't consent, and the conciliation board then either mediates or if there's no way to find a common ground, they decide the case with binding force in many cases, with binding force for the employer as well as the Works Council. The employer, that's not so important for here, I will just mention it, the employer has to bear the costs, so you can't say if you want to have a Works Council you have to pay for it. He has to bear the costs. For example, if the Works Council needs a computer to work efficiently, he has to pay for that. And he even has to release, if the company is big enough, at least some individual workers from their work duties at all. So he can say if there are 100 employees, one of them has to be freed from work at all just to work for the Works Council. And still they have, of course, to be paid for doing something like that. What rights do the Works Council have? We have to distinguish between several types of rights. On the first step, there are only informational and consultation rights. For example, if an employer wants to get rid of an employee before he can dismiss him, he has to first to go to the Works Council, inform them, I want to discharge him, why do I want to discharge him, and he has to consult with them. He does not need the Works Council consent or something like that. The Works Council can oppose, the employer can simply overrule them and say, I will dismiss him. But of course, sometimes the Works Council can convince the employer to refrain from the originally intended dismissal. The next step is that the employer may need the Works Council consent. For example, if he wants to hire a new employee, he needs the consent, or if he wants to transfer the employee to another establishment. However, that sounds very strong and is a very strong right, but one has to keep in mind the Works Council consent can be refused only on certain specified grounds in the statute. So for example, the Works Council can say, I won't consent to hire this person because that's an undocumented worker, because it would be illegal to hire him. But the Works Council has not the right to say, I don't like her, she's not pretty enough, she's not smart enough, she's not well educated enough. That's not a reason. So that's very few reasons that the Works Council can refer to by refusing because he wants to refuse his consent. So it's only on the first glance a very strong right. Much stronger are the Works Council rights as far as social matters are concerned. Social matter, what is that? I put one example, daily working hours. So when do we start, when do we end? When do we have a break? Or another very important example, do we want to have some video camera surveillance in our company? These are social matters. In such social matters, the Works Council has a real right of codetermination. The employer needs the consent of the Works Council in order to take the measure, to say, okay, we start at 8, not at 9 a.m. in the morning. If he does not have the consent, he can't do the measure. And the Works Council is absolutely free to refuse his consent. There are no specified reasons why he can refuse it. So very strong right of codetermination in social matters. And last but not least, we have economic affairs. Economic affair means something like the employer wants to shut down the company, or he wants to dismiss 50% of the employees. In these cases, the Works Council also has some rights. Don't want to go into too much detail here because it's very difficult. The most important one may be the right to demand a social plan, a Sozialplan. A social plan means the Works Council says, okay, you can shut down the company, you can go from Germany to Poland, but if you do so, please pay a lump sum payment to all employees just to make it not so harsh for them, to give them some form of compensation for something like that. So that's the codetermination on the establishment level. The next form of codetermination, I mentioned it earlier, is the codetermination on the corporate level. I think that's something which is not known in the United States, and for which Germany is famous or infamous, depending on which side of view you take. The right of codetermination on corporate level is quite unique in Germany. It's very strong. What does it mean? The right of codetermination on the corporate level is not done by a separate elected body of employment representatives, like the Works Council. The Works Council is only consisting of employee representatives. Now, on the level of corporate codetermination, it takes place simply via the supervisory board. What happens is that the employee sends representatives to the supervisory board of the company, so the employees can directly have a saying in the supervisory board. This may seem strange, especially from American perspective, keeping in mind that a company is owned by the proprietors, and if you send employees to the supervisory board, they have a direct saying about the company. From a property rights perspective, this may cause some problems and may sound strange. However, one has to keep in mind that also we have this right of codetermination on the corporate level. It does not mean that the company is in the hands of the employees. Why is that? The strength, the power of employee representatives in the supervisory board depends actually from the number of employees that are employed by the company. To be more detailed, if you have a company with only 455 employees, there is no codetermination at all. So small companies are exempted from that rule. It starts with 500, and if the company has 500 employees, up to 2,000, 1/3 of the members of the supervisory boards are employee representatives. So 2/3 are from the owner side. So in effect, it may be helpful to get some information, to have a saying, but at the end it will always be ruled by the proprietor side and the supervisory board. Only if the company has more than 2,000 employees, it is on the first glance real codetermination, an equal codetermination, because in this case, half of the representatives are actually voted coming from the employee side. However, if there's an impasse, which is quite likely if both have the same strength, it's up to the chairman to have a second vote. So he will tip the scale, and the chairman is always coming from the employer side, so the owner side. So we have a strong right of codetermination, but also it may be terrifying from the employer's point of view. It's not that the the employees have actually the power to overrule the employer side. So far to the codetermination, which is, I think, more special for you. Only a few words about collective bargaining, because it's more or less the same as the United States, of course. We also have the collective bargaining agreements between unions and employers. They, of course, deal with working hours, wages, retirement plans, and so on. More or less the same. I'm not quite sure, because I forgot it. 6 years is a long time. I'm not quite sure how collective bargaining agreements, what effects they have in the United States. I'm not sure anymore. I just want to point out the situation in Germany. In Germany, we say such an agreement binds all. The union, which enters into the contract, that's obvious. The employer that enters into it, but also the union members. And that's quite important, because we can say the union member can directly go to this employer and say, I'm entitled to this kind of wages under the collective bargaining agreement. He has an individual claim against the employer. He does not need the union to enforce his rights. I'm not quite sure if this is the same in the United States, actually.
Not quite.
Yeah, so that's why I wanted to point it out. That's a very strong protection for the employee. Even stronger, because we also have this statutory division that says, okay, if you want to depart from the collective bargaining agreement, let's say the employer and the employee say, we don't like the collective bargaining agreement stipulation, they can do it, but only in favor of the employee. So they can say, okay, it's only $1,500 a month wage, we want $2,000. That's fine, but they can go down to $1,000. If they do so, it's simply the agreement is simply void, and the employee can always point to the collective bargaining agreement, which is more favorable for him. How do we?
On that, what about issues like movement to a team-based work system in which the workforce is divided? How would you determine what's in favor of the employees?
Movement to I'm not sure if I got the problem.
So let's say there was the employer wanted to restructure work to have more worker involvement in decisions, more responsibility on the front lines for quality and other kinds of things.
Mhm.
And a large group of employees liked this idea, but a large group also disagreed. Would there be a mechanism to figure out whether it was a majority, or how would you determine?
No,
what was
that's
favorable?
nothing up to the majority, and it's nothing up to this individual employee. I try to answer the question, but just one detour. For example, an employee may say, I'm fine with having less wage than in the collective bargaining agreement, but more vacation. That's fine with me. That's not possible under German law. It's an objective standard.
Mhm.
To say it like this, of course, objective will be determined by the
It's
court.
issue by issue.
You got two different things going on. One is the organization of the work, how the work is going to be organized. You have to consult the Works Council on that.
That's true,
But
it's
the
a
Works
different-
Council does not have codetermination on whether they'll be.
No, that's
But the second question is, I'm not paying you on an individual basis, I'm paying you on a team basis, on the basis of team productivity.
okay.
Collective agreement says you must get so many euros. Under this form of organizing, you may or may not get that many euros.
That was the question, okay?
So,
Okay, that would not be possible.
Not be possible.
No.
yeah, I mean,
Um,
there are multiple dimensions to work restructuring.
I
Pay
see.
could be one of them. Yeah.
Okay, I think that's not possible. The Federal Labor Code is very strict about it. So, if, for example, if I got it correctly, otherwise please correct me. If you say the collective bargaining agreement says 1,000 euro a month, and by a system you have in mind, you can get 2,000, but you can also be down to 900.
Okay.
This would not be allowed under German law. At least it's the view of the Federal Labor Code.
And it would not be allowed because it's not in the worker's interest, and then the way that it was determined that it's not in the worker's interest is?
No, because there is the chance that the agreement departs from the collective bargaining agreements to the disadvantage of the employees, because they may earn only 900 euro instead of 1,000. If this was the case you had in mind. I'm not quite sure if I got your case. So if there's a slight risk that you don't earn what is stipulated in the collective bargaining agreement, it will be not to the advantage of the employees. I'm not quite sure about it. For example, just make a case, you have 1,000 euro in the collective bargaining agreement, you have this agreement on the corporate level that says you can earn up to 2,000, but maybe only 980. I would say if the 980 is only a chance of 1%, but the chance that you get 2,000 is 99%, I would say it's more favorable for the employees. But this is, as far as I can tell right now, it's not the Federal Labor Court decision. They always say, okay, you need the 1,000. And if you deviate down, it's not legal.
But there's a lot of pressure on individual, if we haven't talked about sectoral bargaining, you'll get to that, I think. But the individual firm who is bound by a sectoral agreement, doesn't like it, goes to the Works Council and says, let's reorganize work in such a way where the employer is actually paying less. That's illegal. You've said that's illegal. But it's being done, isn't it? They're dealing with the Works Councils on wage issues they're not supposed to deal with them on.
They do it, and often it's working out because no one is suing
No one's
them.
complaining.
Yeah, no one is complaining. But that's not what I want to talk about.
Okay.
Of course, you can do a lot of things on the level. If you know what is suing, it's fine. But from a strict doctrinal perspective, it would not be
Okay.
allowed to do so. It's not up to the Works Council. It's the wrong body to deal with, and it wouldn't be allowed to deviate from the collective bargaining agreement. Okay. Oh.
Yeah, it's, what's underlying this whole conversation is the movement to work arrangements that are more adaptable and changeable under different business conditions,
Mhm.
and a legal structure that is more rigid, and having the two coexist.
Yeah, I think at least in Germany, I don't know about the United States, obviously. If you have a collective bargaining agreement and you have a very stubborn union, you will have a problem because you need the consent of the union. If you don't get it, there's no legal way to do it. You may remember the discussion about Bündnisse für Arbeit. Don't want to go into detail, but it's exactly the same problem. If the union is stubborn, you have no chance. So what employers try to do now is they negotiate collective bargaining agreements that has an opening clause and says, okay, if in this case I can deviate from the collective bargaining agreement, for example, in a settlement with the Works Council. That's possible, but you need a union to agree on it in the first place. If you don't have it, problem. you don't have a problem if the union is adaptable and says, okay, we see the problem. And I think due to the globalization problems, this may change, and unions may say, okay, we can't just stick to the concept of the 1970s, we have to adapt, even if we don't like it. Otherwise, employers will simply try to not to enter into collective bargaining agreements at all. Which brings me actually to my next point, enforcing the collective bargaining agreement. And obviously that's more or less the same as the United States, at least in principle. A union needs some form of pressure, needs some chances to put pressure on the employer, otherwise it would just be collective begging to ask for a collective bargaining agreement. Please give us a collective bargaining agreement. And of course, it's the same as in the United States. They have the right to strike, protected by the German Constitution. However, I don't want to go into too much details, but there are one or two quite interesting differences to the United States, I think. When is a strike legal? It has to be run by a trade union. So a couple of employees deciding we want to go on strike is not legal at all. Secondly, there must not be a duty of peace. A duty of peace means if we have a collective bargaining agreement which is still in force, we can't go on a strike for a topic that is already regulated by the collective bargaining agreement still in force. It must be a legitimate purpose. For example, we can't go on strike. I don't know. We have want a new policy: only hire undocumented workers. To come back to yesterday's lecture. And last but not least, the strike must not be out of proportion. That's a typical example for a toothless tiger. I don't know any strike who was declared unlawful because of that, but don't want to talk about that in more detail. What is interesting from my point of view, for you may be interesting, is the legal consequences. What happens? As far as I remember, even if the strike is lawful in the United States, you can't be dismissed, but you can be replaced permanently.
Exactly.
I called it, Benjamin Sachs didn't like my wording a couple of years ago, but I thought this is absurd. If you can be replaced permanently, that's more or less like being dismissed.
Genau.
In Germany, it's a little bit better. If the strike is lawful, you can't be dismissed and you can't be replaced. When the strike is over, you can come back. You can't be fired, you don't get money, of course. If you don't work because of a strike, you don't get money. But you can't be replaced. So that's much better in Germany than the United States. However, if the strike is unlawful, the employee may be liable for damages. Very difficult because the courts always are very lenient toward the employee and says, okay, we assumed you thought it's a correct strike, it's a lawful strike, we won't let you pay damages. However, if the employee may have known it, there's a chance of damages, and more risky even is probably to be dismissed. So this is something an employee has to take into account if he goes on strike. If it's lawful, nothing happens. If it's unlawful, he may have some problems. That's essentially all I wanted to talk about labor law in general. Let's come to the question at hand. What about union rights to advertise? And I want to split it up in two scenarios, roughly two scenarios. One, do unions have the right to access the employer's premises, the establishment, in order to advertise? And the second one is, can they use the employer's communication systems like the intranet or the business email? I think you talked about it this week, as far as I remember. You will see it's the same problems as the United States, maybe with a slightly different outcome. So the case is probably just easy for you to understand because you know the situation from the United States. The employer employs many employees. Some of them are unionized, and the union wants to gain even more members. They want to go to the premises. And they want to send, and this is important at this point, they want to send one of their members who is already an employee of the employer. And this employee should talk to the other, distribute leaflets and something like this. Can it be forbidden? Can the employer forbid the employee to do so? Under German law, the most important thing, if you want to answer this, is to look into German Constitution, and there we have a section 9, paragraph 3, that says the right to form associations to safeguard and improve working and economic conditions shall be guaranteed. Agreements that restrict or seek to impair this right shall be null and void. Measures directed to this end shall be unlawful. This is the so-called freedom of association. And this freedom of association It's in the Constitution, and normally, like the US Bill of Rights, it's directed or it's applicable between a single individual and the government. So I can say I have the right to form a union, you may not interfere, government. However, due to the second sentence that says agreements that restrict shall be null and void, there is no doubt about in Germany that this freedom of association is applicable directly in the private law relationship between employer, union, and employees. So, for example, if an employee can make the point that the employer's measure is violating the right of association, he can directly point to the Constitution. So, how does it help to answer our question? If we look on the contents, it does not says the Constitution does not say we can advertise for the union, so we have to interpret the statute to see what does it mean. Long-standing German constitutional interpretation says, okay, this section has two parts. It has a collective part and an individual part. The union has the right of association as well as the union member has the right of association. And if we look on the union's freedom of association, a couple of years ago, the German Federal Constitutional Court held, okay, this only encompasses the core of union activity, going on strike, maybe even advertising, that was not clear. However, sensibly, the court gave up this very narrow interpretation and now says, okay, the union's freedom of association actually encompasses all activities that the union deems necessary to achieve its goal, so to get better working conditions. And of course, there can be no doubt about it, recruiting new members, advertising for new members is necessary to achieve one's goal, because otherwise, without members, you don't have enough manpower to go on strike, you don't have enough money from membership fees to finance your campaigns. So therefore, there can be no doubt about it that union advertising is protected by the German Constitution, by the right of the freedom of association. Secondly, as I mentioned earlier, also the employee's freedom of association is protected by the Constitution, and this not only encompasses the right to found and join the union, but also to engage in union activities. So in my case, I think it was named M, the employee who wants to go on advertising purposes, he also can refer to the German Constitution. So it seemed to be quite easy, but on the other hand, we have the employer who also has some legitimate interests and rights. And what are these rights? So what is this right, essentially? One can say the employer has also protected by the German Constitution the right of entrepreneurial freedom. It's not always easy. Entrepreneurial freedom. And of course, what can he say? He can say, I don't want to be my workflow disturbed by union activity. I pay for the worker to work, I rent a place, I own a place to work, and I don't want any union talk here because this may actually disturb my workflow. This is a legitimate, protected interest, no doubt about that. And as in the United States and probably in all developed countries, what we do have to do now is simply balancing and weighing these interests against each other. And I'm now referring my own opinion, and for one rare case, even the opinion of the German Federal Labor Court. Normally we dissent, but in this case we consent. What do we say in Germany about this problem? The German Federal Labor Court says a complete ban on union advertising on the employer's establishment would not be lawful. So in general, the union has the right to send an employee to advertise on the company establishment. The reasons are easy. Advertising is, as pointed out earlier, absolutely central for the union's purposes. And advertising on the establishment is maybe the only effective means to do so, because the establishment is obviously the natural, the logical place to advertise. That's the place where the employees meet. All of the employees will be on the premises sooner or later, apart from telecommuting or something like that. They meet there. So it's much easier to reach them on the premises than outside in a bar or knocking on their doors at home. Secondly, of course, an employee who is at work probably is thinking about work. Whereas if you go home, knock at his door and disturb him while he's watching football, he may not be eager to talk about, I don't know, working conditions. So that's absolutely crucial to have him on the premises. Last but not least, maybe in where I come from, a small village with 50 people, there are no factories, but if there were a factory, you can easily contact all employees. But how can a union in a big city like Chicago or New York get to all the employees outside the factory? They don't know probably the names of all employees, they don't know their addresses and so on. So it would be very, very difficult to advertise outside the establishment. Therefore, a complete ban is not legal in Germany. However, if you look on the first bullet point, still there is the employer's legitimate interests. How to protect them, what to protect. German court says, okay, we have to take care. First of all, the employer has a legitimate interest that the union is behaving itself on the, let's say it like this, on the premises. So no bad mouthing of the employer, no giving out false information, no disturbing of the work peace. That's one. You can do it maybe outside of the establishment, but definitely not on the establishment, not on the premises. That's one point. And the other one is obviously you have to take care that the employer's workflow is not disturbed at all. So you can't do it during work. You have to do it in breaks or before and afterwards. But as long as these criteria are met, it's fine. You can go to the employer's premises and do the work, do the advertising. So answering my little case, I can say a complete ban would be illegal, but M has to stick to these rules I laid out before. Another question, which is, as far as I remember, also addressed in the United States, is the question: what happens? Does a non-employee, member of the union, but non-employee of the specific employer, have an access right to the premises? There was a lot of discussion about that in Germany for a long time. Now it's more or less, it seems to be more or less settled by the Federal Labor Court, who says yes. In principle, even non-employees have an access right, unless, and I try to quote, unless the employer demonstrates a predominant interest. Whatever the court does mean by this, I don't know. It does not specify what this predominant interest may be, and it especially does not say how the employer can meet this criterion and point to it. I'm not quite sure if this case is decided correctly. Okay, I pointed out advertising is very important and on the establishment level as well. But just saying yes may be too easy. I think one could make the argument that the employer has not only the right of entrepreneurial freedom, the same is true as I talked about earlier, but he also has another right which plays some rule in this case. And this right, I would say, is the right of domestic authority. He has the right to decide who he wants to be on his premises and not. Of course, if the person who is doing the advertisement is an employee, it will be on the premises anyway. That's no problem. But if it's a non-employee, the picture, I think, changes, because this is a person the employer does not originally allow to be on his premises. Keeping that in mind, I would not say you can completely ban union advertisement by non-employees on the premises, but you should restrict it even more than what I pointed out earlier. I would say you can do it only if the union can say we don't have an employee, a member which is already an employee. So I would say it's like a subsidiary rule. So if you can send a non-employee if there's no employee who is already a union member. Or the union may say, okay, we have an employee here, but he is not capable to doing so, or not willing to do so. We need someone who is better trained. So that may be the first step, I would say, is necessary. Of course, the union can always try to excuse that they have already an employee working there, because in Germany, an employer is normally not allowed to ask, are you a union member? So this may admittedly be not really a big obstacle to overcome for the union. But just from a doctrinal point of view, I think it's more convincing. And the second obstacle I would say is necessary, apart from what I mentioned earlier, that you should not badmouth him, you should not disturb the peace of the company, is of course that the union has to make sure they have to work together, let's say it like this, that the company secrets are preserved. If there's an employee who's doing the advertisement, okay, that's fine, he's already on the premises. But if a non-employee comes into the company, there must be some safeguards that the employer's secrets are not violated. Maybe that's more up to the employer to do so, but still the union, I think, also has some form of obligation to say, okay, we understand he can't enter all parts of the company. Maybe you just reserve the canteen or something like that.
That was my question. Because you're assuming there's a disruption, a potential disruption of greater potential if this is a stranger to the enterprise. So, but the company has a parking lot. And the union representative, who's not an employee, sent by the union, wants to hang out in the parking lot and speak to the workers when they enter the plant and when they leave the plant.
Mm-hmm. Yeah,
That would be allowed under German law.
It would be definitely allowed under federal labor, what the labor court says.
Yeah.
From my point of view, the parking lot is part of the premises, so I would still apply this this rule here. I would still say this. As long as it's the premises, I think the employer could ban it. If there is a suitable, willing employee who is a member of the union, I would say.
Well, you might also say that if it's just in the parking lot, its domestic authority isn't really being affected. Yeah, that's right.
No, I would not say that. I think domestic authority also applies to the parking lot.
Property.
All right.
Yeah,
right.
that is a very property-based point of view.
This is a question of whether there's a spectrum here or just we have buckets. But either way, so my question was, why would they be using a non-employee to begin with? It's either to be disruptive or because they want to protect the identity. They don't want anyone to have to reveal that they are actually part of the union.
Mm-hmm.
Are there other reasons too, or?
I would simply say maybe there is no employee. There's no employee employed who is a union member, for example. That may be one.
That's what
or
you're
he's maybe
thinking
just
here.
incapable of doing so. Not everyone is able to speak to 100 people.
And what about the identity protection reason? How do you feel about that?
Could also be a reason, valid reason, yes.
Well, but then if we went with your rule, then how would that work? So suppose that they want to use a non-employee because they don't want any of the employees who are members to be outed as members of the union. And so they're choosing to use a non-employee. There are employees who are members. The domestic authority might be affected by them using a non-employee, but so then what, we have to balance the interests of anonymity versus...
Maybe I didn't make myself clear enough. I would say from a theoretical point of view, but it's a theoretical point of view. You have no access right of non-employees if you have a capable, willing union member which is an employee.
That's your position.
That's my position. Yes, that's not a federal labor court decision. That's my position.
Yeah.
But from practical matter, of course, the union can always say, oh, we don't have a member who is an employee, so we have to send a non-employee. So that's what I meant earlier. Maybe this is just a theoretical discussion. Especially, as I mentioned earlier, the employer must not ask if you are employed, if you are a member of the union or not. But I would just say, if there is a capable, willing employee who is a member of the union, why should you send a non-employee? Why? What's the reason? Unless he's much, much better, as I pointed out, which is, of course, very subjective.
Unless he's much better or he doesn't want to be outed as a union member.
Yeah, that would be something like unwilling to give a speech, yeah, maybe.
No, he's afraid. I mean, take this scenario. The reason you want to say there are no members in the enterprise. You want to get members in the enterprise.
And it's easy.
Now, the way you want to find those employees who are the natural leaders of the work group and enlist them to support the union. Maybe those employees are members of the Works Council.
Mm-hmm. Often.
So you want to get these Works Council people to join the union and become union leaders.
Mhm.
How do you reach them except if the Works Council has an office which is not a work area? You send a union rep to go and meet them in the work and try to set up something outside the plant, or right? As I understand, the Federal Labor Court would say yes, the union can.
Yes.
Yeah.
Yeah, they for that there's no problem. For me, this is a very doctrinal
That's
perspective.
because you're Harvard educated.
No, that's because I'm a theorist. That's the reason for that. Maybe in practice I will not be able to uphold this distinction. That may be true. But I think it's, again, I have to quote the labor court, unless the employer demonstrates a predominant interest. What is that? That's not clear at all. That's not practically either. So I just was making my argument. I just want to be to make more aware that this is not. I think it's not selbstverständlich.
Self-explanatory.
Self-explanatory that you have access right for non-employees. That's just maybe just not even a rule of law, but rather a message to the unions, take care, do you really need a non-employee to do the job? If so, okay. Okay, if you have only one carpenter who is not able to speak to more than one person at the same time, okay, then send your professional advertising guy. But apart from that, maybe you should refrain from doing so. But at least it's one opinion, and no one will listen to me anyway. So, you.
Join the club.
Just as a footnote, what proportion of the treasury of a German union, or what proportion, or if there's variation across unions, how much time and resources do they devote to reaching out to organize new members? Is this a common thing, or?
I think
just by way of contrast, this is a big debate among U.S. unions as to how much of their time and resources should go into representing their current members through collective bargaining and so on, versus trying to organize new members.
You are probably much better to answer this question, because I'm only serious. I'm not aware. German scholars don't like something like empiricism.
Empirical research.
We never do that, so I can't answer it. I'm just guessing now. I think until 1990, no one did it, because there were the number of.
In some sense, this is
but it dropped.
somewhat hypothetical.
No. Some unions are starting now. They're building organization departments, and they're trying to figure out how to do it. That's why this law is important.
Yes, but I have no figures. I can't tell you. I would still think that
IG
most
Metall-
part of is
IG
devoted to
Metall
political
has-
work and collective bargaining.
IG Metall has six
Organized.
organizers.
Okay.
But they plan to grow that department. Right now, how many members does IG Metall have? It's huge.
I don't know, 100,000.
Yeah, and that's 6 organizers.
So it's really not that big an issue so far.
But where they should be growing is in the service industries. And they're not organizing at all.
Yeah, they're still relying on the old, we are good for you, you will come to us anyway, which may be correct, I don't know, but fact speaks against them, because dropping all the numbers of employees that are member of the union. So one last part I want to talk about is what about using the employer's internet communication systems like the intranet, or sending emails to the business email addresses. To be honest, this is nothing so spectacular anymore, because that's more or less the same debate now that we had just now. Of course, on the union side, we have the freedom of association. Advertising, of course, also encompasses the right to send emails, to use the intranet. One just has to make oneself clear that this new form of communications are very effective, much more effective than the old one, much cheaper than printing leaflets and distributing in front of the premises. It's much cheaper to send just an email. So the interests of the unions are quite at stake, and it's quite important for them. On the other hand, of course, the employer, again, has the entrepreneurial freedom. He has property rights, from my point of view at least. Some very difficult, but I think you have to pay to have email addresses. I don't know, to Yahoo or something like that. So this is something which has a property rights, and of course there's also the safety issues. Luckily, we had a decision by the Federal Labor Court. They balanced it, and they also said, okay, in principle, you can use business email address. You can send emails to business email addresses as a union to advertise. And then there's typical court decision, typical German court decision. They said, okay, you can use it in principle, but frequency, length, and content of such emails could make sending emails unlawful. So that's quite difficult. In the case, the court had to decide. The employer made the argument and said, okay, I have 3,000 employees. If half of them read this specific email, it will take up to 170 working hours, paid working hours. That's illegal. The court says no. I'm just wondering, where's the border? Where's the boundary? If I make a quick calculation, 3,000 employees, 8 hours a day, that's 24,000 hours a day. That's a month multiplied by 20. It's around about 500,000 working hours. So 170 working hours, paid working hours are fine. What about 10 emails per month? No one knows. So it's a typical court decision, leaves everything open. It's okay that they say it's to send emails. In principle, it's okay. I would totally concur with that. But I think this decision leaves all questions open. Because if you are a union, you already had sent 5 emails this week. Can you send another one? Or if you are an employer, you already saw there are 5 emails this week. Can you get an injunction against having a 6th one? Who starts doing that anyway? So So it's a rather difficult question. At the end, I would say, in Germany, it's more or less that you can use the email addresses all the time.
But not too much.
Yeah, but at the end, I don't think that someone is, maybe if you send 10 per day, then you get into trouble. But if you send 1 or 2 a day, no one will sue.
And what was the remedy if they did send too many? You said maybe an injunction on the subsequent emails, or would it be bar on all future?
A good question. I think no barring for all the future would not be possible. No, not at all. That's not okay. Maybe the employer could go to court to seek an injunctive. Is it? I'm not quite sure about the word anymore. Injunctive, so a short-term decision by the court, and say you may not send another email this week. But who does that?
Maybe damages for the working hours or.
But to get damages, you need at least negligence from the union's part. Difficult to explain because as I said, where's the border? Is 5 is too much, or 5 is okay, 6 is okay, 7 too much?
And these employees are reading emails from their kids, they're doing all kinds of things on this machine, on work hours.
Yeah, so I think at the end there are no
And maybe
remedies.
they're reading it during a break, which is not a work hour. Or even
Yeah, that would be okay anyway. Okay, so I think at the end the answer in Germany is yes, you can use it.
Does a company have to provide email addresses
To the union?
if they ask?
I would say no. No, that's not up to the union. They have no information right against the employer. No. But I think it's rather easy if you have a list of names. Your email address is always the same, Matthew Thinking at University of Illinois DE or something, com or something like
But
that.
how do they know?
If they have a list with names, then it's easy.
How do they get the list?
If they don't have the list, it's their problem, of course. They have no information right against the employer.
The employer has no obligation to
No.
turn these names
No,
over.
no. That's not, okay. And about the intranet, it's more or less the same. There's no court decision, but I think if someone is stupid enough to go to court, it will have the exact same result. Where's the big difference between business email addresses on the one hand side and the intranet on the other hand? And even more, one can point to one thing which is a long-standing tradition in Germany. A couple of, in the 1950s, the Federal Labor Court says the union is allowed to use the bulletin board of the employer. So the classical bulletin board. And I would say the intranet is the modern form of bulletin board. So even more, there's an argument to say the union may use the intranet. But again, of course, they cannot swarm the intranet. And there's no information from the employer anymore, but only union talk. That's for sure as well. But where's the boundary? So at the end, for one last sentence, I think the result is even more positive from the employer side. We have strong rights of union advertising on the premises and using the employer's communication systems.
If the union, let's assume it's a greenfield facility.
What is a greenfield facility?
Brand new plant, brand new office.
Oh, okay.
American multinational comes in there, 200 workers.
Mhm.
Union targets them.
Mhm.
The union wants to get their email addresses so it can get their message out to them.
Mhm.
Wouldn't German data protection law prevent the disclosure of those?
That's the thing,
yeah.
yes. Even if the employer would be willing to give the email addresses, you will at least have to think about protection law. I think business email addresses may not be protected because where's the interest of the employee? If the employer
doesn't want to get the messages. It doesn't want the union to know what their address is.
I'm not a
Gets
big
us
fan of
into-
data protection law anyway, but I think in this case it's a little bit too much.
Well,
of
the
data
company
protection.
has a directory, and if someone will leak the directory of its employees to the union, directories very often have the email addresses of every employee. Or is
If it's a private email address, I totally agree with you. There's no reason to give out to hand over a private email, but a business email you can
it's at
say.
the company? Yeah.
Yeah, but you can always, in most companies you can just go on the internet and check, and there is the business email address anyway. So I'm not quite sure if you have a strong data protection problem with this. You have to take into account, obviously, but as a I don't know, from my point of view. But as I mentioned, I'm not the biggest data protection lawyer for all times.
Using it. I'm using it, not reproducing it. The Spam Act, there is some cases where it's tried to be used against unions, and those cases have failed. So a little bit of law on that.
No idea about copyright law. I'm sorry about that.
No?
Not at all. So I'm.
Hard not to.
So I'm wondering, so do you think that these decisions about communication systems are going to put pressure on the rule about
the premises? I mean, so if there's greater access through technological means to the employees, isn't that mean that there's just less and less reason for employees or non-employees to be doing union activity on the physical premises?
Yes and no. I think, indeed, one could make a point to say, okay, you can use the internet. Why do you have to come to the premises anymore? But that will never happen in federal labor court in Germany. Because you would say you have one mean more, you have one advantage now more because you can use the business email address. We take this as an argument to take away entrance rights to the premises. No, not on a German federal labor court, because they are more in favor of the employee. So they will never take this argument, I guess.
But there's a contrary, there's a difference between getting a message and actually confronting a human
Apart from
being.
that anyway. I think it's much more advertising if I speak to you in person than just getting, don't want to insult your card, but just to get something like this.
Yeah, I mean, I can certainly see why unions would want to have physical access as well as technological access. It's just, if the reason for having physical access to begin with was the assumption that there was no other way that the union could access these people, it's not true anymore. I mean, although it's less true if the company doesn't have to provide their email addresses,
Well,
so.
but the trend line, we had a recent seminar with the senior vice president from Boeing, in which we said, well, what will your work look like in HR in the year 2020? And he said the first assumption is virtually every piece of information that we consider private or confidential will be public in one way or another. Employees are posting their salary, their working conditions. You know, somebody can pretty easily do a search and find all sorts of things, and by the year 2020, the assumption is everything will be open. So in that sense, the physical premises won't have changed, but the degree to which lots of things will be happening in cyberspace by way of collective organization of many kinds will only be increasing.
So even less reason to guarantee access to physical premises.
Just to be clear, I totally agree with you on a doctrinal perspective, on a theoretical perspective. Just my assumption that it will actually change the court decisions in Germany, that's the difference. I think they will never change it.
Well, I agree with Arden to this extent. Unions do want to get
Right.
right? But what you're saying is because our law makes it almost impossible for a union that doesn't have people in the plant to get the message to them, basically impossible. They're driven to to exploring these alternative means. But that means greater ventilation of all this stuff the employer doesn't want to have ventilated.
Right.
It's a
Right.
consequence of its own denial of human access. So, what comes around goes. It's an interesting.
It pushes a
yeah.
lot of things into open cyberspace that wouldn't normally be.
Yeah.
Interesting. You've been very provocative.
That's only the tip of the iceberg.
Yeah.
You should hear me speak in German.
Sie spricht gut Deutsch.
You are speaking German?
I could once speak German.
Any other questions for Ms.
I have a couple of
Fisher?
questions.
Yeah.
You were talking about Article 9, Paragraph 3. If I still remember it, that's a fundamental right. So, but this, in the tradition of German law, the fundamental rights applies in the horizontal relationships between
Vertical.
the vertical relationship between the power and the citizens. You are applying Article 9 on a constitutional basis or by means of a legal development of this article. So can the employees or the unions challenge a decision of the employer directly invoking the
Yep.
So all this traditional doctrine of the indirect effectiveness is overruled.
No, it's not. This is very doctrinal now. I'm sorry for that.
That's right. Drittwirkung?
Yeah,
Yeah.
he's referring to Drittwirkung, doctrinal. So normally, as you point out, we have the government and we have the citizen, and basic laws are only applicable in their relationship, but not between you and I.
Two private.
And to circumvent this problem, let's say it like this, we have a lot of statute in Germany. We refer to say, okay, when we interpret the statute, we look onto the basic rights. So we have the indirect influence of basic rights. But there's one exception, that's the freedom of association.
Just
That's the one, yeah, that's the only exception. There's another one who no one cares about. And this is just because of the second sentence, which directly says agreements. Agreements are unlawful. And agreements mean private law agreements. And the second half sentence, measures, means measures by private individuals. That's the only reason. It's directly in the Constitution that's directly applicable between them on the horizontal basis between employers and employees. But that's the reason for that.
And second question, does these advertisement rights of the unions or of the employees apply also in the public administration, in the government units?
Yes. Sure. You have at least as much rights against a public employer than against a private employer, of course. In most cases, you have more rights.
Any further questions? We're just about run out of time. Philip?